An arbitration clause can go inside almost any type of contract or agreement. Each clause enforces parties to resolve future legal disputes through arbitration instead of court litigation. This way, a legal resolution is guaranteed to take place outside of the U.S. court system. Don't expect most arbitration clauses to be long or complicated. Many of them are only 1 or 2 paragraphs long. The U.S. government upholds arbitration clauses in every state in the country. Why? Because the court system is overburdened with too many cases. That's why many public court hearings are scheduled 1 or 2 years in advance. Meanwhile, arbitration is a private process for resolving legal problems outside of court. Support for arbitration clauses come from the U.S. Federal Arbitration Act. The act ensures that binding arbitration can take place. When arbitration is binding, parties forfeit the right to appeal the decision of the arbiters. Thus, each binding decision is final and courts cannot overturn it except under limited circumstances. This is why almost all arbitral clauses refer to binding instead of non-binding arbitration. Since arbitration is binding, most clauses are known as mandatory arbitration clauses. They require each signing party to accept the other party's pre-dispute terms for arbitration. Many companies insert these clauses into consumer contracts. Here's an example on how mandatory arbitration clauses work. Say that a car dealership makes customers sign an arbitration clause. This means each customer leasing a car waives his right to go to court should a legal dispute take place. Mandatory arbitration clauses are becoming increasingly popular. You should find them in all sorts of transactions, like opening up a credit card, renting an apartment, and buying software. There are many benefits associated with arbitration, such as saving time and money. Oftentimes, litigated court cases get scheduled years in advance. That is never the case with arbitration. Through the protection clause, you won't have to worry about potentially wasting countless hours and dollars in court. The arbitration process is fast and efficient. Many disputes get resolved after only 1 or 2 hearing sessions. Plus, adding a clause to a contract can protect your personal and business assets. That is why our association encourages individuals and companies alike to use arbitration clauses. Again, do not assume that drafting a clause is extremely difficult. Here's an example of a basic arbitration clause. All named parties within this contract agree to resolve every potential legal dispute through binding arbitration. These parties will not file a civil lawsuit. Instead, they will engage in official arbitration methods and rules per arbitrationagreements.org. Keep in mind that you can tailor arbitration clauses in any manner that your party prefers. Here's the basic information that your clause should mention. 1. Each name of the party affected by legal terms within your clause. 2. Date that the clause goes into effect. 3. The date that the clause expires, unless you do not need an expiration date. 4. Whether or not a party has the right to change certain clause terms in the future. 5. Legal consequences of parties violating terms within your clause. Do you or your business need help drafting an arbitration clause? If so, please feel free to browse our website of our association, arbitrationagreements.org. You can view and download sample clauses on the site and learn more about how to use legal language. Our ADR experts can even draft an arbitration clause for you today. If you would like to get started, call us right now at 844-554-0444. Within minutes, our arbitration professionals can draft a clause that fits your exact legal needs. This way, you can protect yourself, your business, and your assets.